Welcome to another episode of Brick by Brick, Building Wealth Through Real Estate. My name is Nico James-Bock. I'm a broker with Royal LePage Signature in downtown Toronto. In today's episode, I want to talk about understanding assignments and subletting as they pertain to landlords and tenants. My special guest in today's episode is Zachary Soccio-Marandola, a lawyer based in downtown Toronto. Zachary, if you could make your presentation, present who you are, what you do, and then we can get started with the subject of today.
Absolutely. And thanks for having me, Nico.
Welcome.
So like you said, my name is Zachary Soccio-Marandola. I'm a real estate lawyer here in Toronto. I have previous experience working as a real estate broker for about 6 years, and then I transitioned that into my law practice where we now focus solely on real estate issues. So today we're going to talk about understanding the assignment and subletting rents when it comes to residential tenancy. So there's kind of a little bit of confusion, especially when it comes to both the landlord and tenant's rights in terms of how to use both of these situations. So the key point is when we're talking about assignment of subletting, we should start with what is the actual difference. So when we're talking about an assignment, this is where one tenant is essentially replacing another. So the agreement gets amended. Now, the original tenant comes off the lease. They're no longer responsible to the landlord for the monetary payments or any obligations. The new tenant comes in and takes over the same terms and conditions and is now the person responsible. Now, in terms of an actual assignment, there is no inherent obligation or right where a tenant can assign the unit. They have to get consent. And this is where that confusion usually stems. So there's two levels of consent when it comes to an assignment. So a tenant himself can request to the landlord that they assign the unit, and the landlord can respond either granting the consent or refusing it. Now, if they refuse the assignment, then the tenant is not able to assign it to anybody else, but this does give them a certain right of termination. So if they ask for an assignment, it's refused, they're able to provide 30 days notice to the landlord and terminate the actual tenancy. Now, there's a
Yes, that's
situation. Go ahead.
not to interrupt, but I guess that is also um, a lot of confusion around assignments in general is not only in the tenant world, but it's also in the resale world, where a lot of buyers believe they have a right, an inherent right to assign an agreement of purchase and sale. I guess just like in the tenant realm, that right is not inherent. It can be granted, but it's not a guaranteed right.
Yeah, and it differs in that because when we're dealing with agreement of purchase and sale, it's contract. So that can be written differently. Whenever we're dealing with tenancy, we have to adhere to the Residential Tenancies Act, and any lease agreement can't contradict that. So we can't contract out of the RTA whenever we're dealing with a lease agreement. So we can't necessarily change these assignment and subletting rights through a lease because essentially they
Okay.
would just be unenforceable.
Okay. So you mentioned there are two stages of consent.
Yeah, so there's that general consent. So if a landlord flat out refuses any type of assignment, the tenant actually has a right of termination where they can give 30 days notice and terminate the lease agreement.
Okay.
Now they can agree to a consent. And then we get to that second level of consent where we're talking about consent to the specific assignee. So a landlord can say, yes, you're able to assign the unit, but they still have to approve the new tenant. Now, there is an obligation where a landlord cannot arbitrarily or unreasonably withhold their consent. And that's where that confusion really comes into play. Because a lot of people mistake this for being an overall right where they can't unreasonably refuse the assignment. Now, they can refuse for any reason on the general term of assignment, but if they grant the right of assignment, then that obligation comes into play regarding the specific assignee. So if you say, as a landlord, yes, you can assign the unit, you still have another level of approval. you have to then approve who the tenant is assigning it to. And at that point, that obligation kicks in where you can't unreasonably or arbitrarily withhold that consent. Now, it doesn't mean you have to agree to anybody. You still continue with your regular vetting process in the same way you would vet a tenant as if the property was vacant. But at this point, you're doing it where the current tenant is finding potential applicants, providing you with the information, and you're making a decision at that point whether or not to allow the assignment.
Okay. And if the second tenant is not does not have the creditworthiness or the employment qualifications, then obviously the landlord can then refuse that second tenant. And then what happens? The first tenant will have to go and find another tenant, or the process ends.
No, they can continue to find another potential assignee.
Okay.
And at that point, too, if the tenant feels that it's being unreasonably withheld or without good reason,
Okay.
they at that point can apply to the landlord and tenant board for a decision on that.
I
Now,
see.
logistically, how that plays out, it's quite a long time just to get a hearing on a matter like that. So it's not really a practical remedy, but that is the actual legal remedy for that case. So a tenant who feels like their assignment is being refused to the specific or potential assignee unreasonably, their only option is to go through the landlord and tenant board to prove that. Now, obviously, as a
Okay.
landlord, they're going to have a chance to prove the reasons why they withheld consent. And if it is for legitimate reasons, so say, the potential assignee wasn't employed, or they didn't feel they had the credit to actually be a viable and strong tenant, then that is still within their rights.
What is the timing typically at the landlord tenant board to get a hearing for such an issue? Is it based on the general backlog at landlord and tenant, or is it based on importance of the issue? Like, where does this stand in terms of importance
Yeah,
of
my
landlord tenant
understanding this would
hearings?
be similar. I haven't brought an application on behalf of a tenant in this situation, but my understanding is it would be in the general application. So that's right now we're looking around 6 to 8 months in our experience. The only applications that are actually prioritized are rent arrears, which usually we're looking at around 3 months when you're
I
serving
see.
an L1 application, and then special circumstances. So we've had issues where the actual breach from the tenant when representing a landlord was so severe that we basically add a motion or submit a motion to the board. There's pressing circumstances that require a quick hearing, and sometimes they do grant this.
Ah, interesting. Okay.
Yeah, so I mean, in this, that's the clause I was referring to that often gets misinterpreted. So a landlord shall not arbitrarily or unreasonably refuse consent to an assignment of a rental unit to a potential assignee under clause 3B. And that last part's the important part. So where it says to a potential assignee. So this doesn't apply to the granting of consent for assignment. It only applies to the potential assignee. So again, that means a landlord can arbitrarily and unreasonably refuse consent in the general term. So again,
Right.
no landlord has to agree to an assignment.
Okay.
Yeah, so it's that two levels that gets kind of
Yeah.
confusing.
Yeah. And it's confusing on both the landlord side and the tenant side. Do landlords understand this as well?
I mean, our experience, I guess, would be biased because we do work a lot more with landlords than tenants. So that's
Okay.
often where I'm seeing the confusion in our
I see.
practice.
Okay. Okay. How common is an assignment of a lease? Like, how often are you seeing that tenants are wanting to assign, and are they assigning because of financial reasons, or generally because of um, change of job, change of location? What are you finding the reasons are, and how long, and how frequent are these assignments that you're seeing in your practice?
Yeah, in terms of the frequency, it's difficult to say because it depends when we're actually engaged.
Mm,
And sometimes landlords, if they're, experienced at this, they handle it themselves. But the times we have been engaged to help with an assignment of a rental unit, The most common reason I see is a relocation of job. Now, in
Okay.
terms of the frequency, it's really just depending on the facts or situation where a tenant actually needs it. I don't think it's overly common. We deal with usually a few per year, at least that come through our office. But like I said, there
Okay.
are definitely situations where, a landlord handles it themselves because, of course, there's no requirement to engage a lawyer to help them with that.
I see. They just fill out the proper paperwork as usual under landlord and
As long as they're
tenants.
comfortable doing it. Again,
Yeah,
for some landlords, we get more involved just based on their comfort.
correct. Okay. Understood. Understood. Okay. Um, want to just go over quickly the consequences of refusing general consent.
Yeah, so that it's a lot more powerful than most people realize. If you do refuse that general consent, you actually do give the tenant a right of termination. So if they do want to get out of the lease and they ask you for an assignment and you say, no, I'm not allowing this to be assigned, then they can go ahead and submit a notice, which in that turn can be up to or to be about 30 days notice, and they can terminate the lease if that general consent is refused.
Okay. What is the form for the tenant if they want to
In that
terminate it?
situation, they'd use an N9 form.
N9. Okay. For early termination. Okay. Excellent. I want to touch on briefly a situation that I came up against with a tenant who wasn't clear on the dates. Um, Even in this case, the dates that either a landlord or a tenant uses on these forms is crucial. In the situation that I'm referring to most recently is a tenant wants to terminate the tenancy. They fill the N95 form, and for the termination date, they calculate 60 days from the date they decide to end the tenancy. So in this particular case, it was October the 6th. He calculated 60 days from October the 6th, which brought him to December the 6th. And that's the date that he used on the form. The property manager who's handling the tenancy for the owner landlord got back to my tenant client just with an indication that the requirements have not been met, and my client didn't understand because they assumed it was just 60 days. So I explained that the termination date of your tenancy is actually the end of the period, not 60 days from when you decide to end the tenancy. So this is a regular tenancy that turned into a month to month. The end of the period was the end of the month, so 60 days from the date that my tenant client decided to terminate the tenancy would actually fall on the 31st of December. Could you flesh that out a little bit in terms of the
Absolutely.
importance of using those dates when giving
Yeah,
notice?
so in that situation, when a tenant's looking to end their tenancy, it's that Form 9, again, that notice to terminate a tenancy. Now, in that situation, if you're on a 1-year lease, you can't use that form until the end of the actual lease term. So, for example, if you're 5 months in, sure, you can give an N9, but that termination date has to be the end of the actual lease term. Now, once that lease term is up, tenant goes to month. They then can provide that with 60 days notice. But it's not just a straight 60 days. It's 60 days ending on the end of a rental period. So the most common rental period we see is, monthly tenancies. And that's what happens when you go month to month. You're renewing technically automatically every month. So that's that 60-day requirement. It has to be the end of the month. So in your situation that you're referring to, if a tenant is giving that notice on October 6th, it's actually closer to that 90 days because it has to be 60 days ending a period. So it would be not the end of November, but the end of December. So December 31st, which means whether they provide notice on October 2nd or October 31st, their termination date will be the same in both situations, even though they're almost a month apart. The earliest
Correct.
termination is going to
Yes.
be December 31st.
Excellent. Thanks for that clarification. Very, very useful because that comes up a lot. Tenants do not generally understand the dates used on these forms. Okay, I'm going to provide your contact information. Thank you so much for this time. Um, Assignments and landlords and tenants' rights often come up in real estate. I believe there are more rentals as opposed to sales, simply because rental tends to be the price point at which most people are able to get into the real estate market, as opposed to having to put down a hefty down payment. Thank you for your time, and we will talk soon. The next topic will have to do with assignments as they pertain to agreements of purchase and sale. So look out for that topic as we conclude this episode of Brick by Brick, Building Wealth Through Real Estate. I'm your host, Nico James-Bock, together with my guest host, Zachary Soccio-Marandola. Thank you.
Thanks for having me, Nico.
Thank you. Just going to end the recording.